Hello, everybody. My name is Duncan Hardiman. I'm an AmeriCorps Vista, currently serving at Pennsylvanians for Modern Courts. I'm going to put a quick poll up on your screen just with a little bit of demographic data that is optional, but we mainly want to know about if you have experience in the courts previously. We're gathering this information for our funders, our board that are very interested on the impact of who is coming to these workshops and what communities we're really impacting with it. So if you guys could just answer these questions real quick while everybody else trickles in, that would be excellent. Thank you so much.
Okay. I'm going to give it one more minute. Oh, here comes Lori. Got it. Okay, whoops, that's interesting. Okay. Okay, great. Hi, Lori. Oops.
Hello.
Okay. All right. Well, I'm going to begin. I want to say thank you, everybody, for joining us. I'm Debbie Gross. I'm the CEO of Pennsylvanians for Modern Courts. This is part of a series of programs that we are collaborating with the Allegheny County Law Library and the Carnegie Library, and this is our second in the series. We have another program April 6th on how to administer an estate, and another program on May 4th on court basics. So, please sign up, please join us. Also, we have many other programs on Pennsylvanians for Modern Courts websites. For example, there is one on March 16th about threats to the independence of the judiciary. So again, thank you for joining us. Okay, a little bit about Pennsylvanians for Modern Courts. We are a statewide nonpartisan organization. That's really important so everybody understands. And we are focused on access to justice, having people have confidence in our courts, that they would be heard by a qualified, fair, and impartial judiciary. And again, I want to thank Jessica Bayless and Lori Hagan. Jessica's with the Carnegie Library, and Lori's the reference librarian at the Allegheny County Law Library. I don't know, Jessica or Lori, if you want to say anything, but you are more than welcome. Yeah.
Jessica, you want to go first?
Sure, yeah. Thank you for joining us. Thanks for including us, Pennsylvanians for Modern Courts and Allegheny County Law Library. Civic CLP is a new grant-funded initiative through Carnegie Library of Pittsburgh, where we do programs just like this, engaging with partners in the community on topics of interest to them, and is just your place to learn about civic life and the importance of the First Amendment through programs, services, and information resources. Take it away, Lori.
Okay, hi. Lori Hagan here, reference librarian extraordinaire. Sorry. And we're hosting this workshop as part of our mission for equal access to justice and community outreach programming for the residents of Allegheny County and surrounding areas. We have materials here. We've added a bibliography of sources that we have here that can be used. You don't have to be a member to use the library, but you do if you wanted to do Westlaw Alexa searches or wanted to check any books out. But you're welcome to come and peruse what we have. We can help you find materials on any topic that you need and assist you with legal information. We are not attorneys, so we cannot give legal advice or interpretation or help you fill out forms. That being said, we're on the 9th floor City County building. We're open from 9 to 4:30 Monday through Friday. Thank you.
Thank you both very much. We really appreciate this collaboration. And we have amazing speakers today. And I say this because they are both, I am fans of both of them. They have helped PMC over the years. While I am new to PMC, I would like to say they are actually not. And so our speakers are Julie Colton, who is a partner at Obermeyer. Julie actually helped PMC with a program that we hold about journalists in the courts. Julie clerked for Judge Kim Eaton in Allegheny Court of Common Pleas Family Division. She is an adjunct professor at the University of Pittsburgh Law School. She is very involved in the Allegheny County Bar Association, in the Court Relations Committee, the Treasurer, the Guidelines Committee for the Family Law Section. She publishes all over many articles on family law, which is really remarkable because she is a mom, and really does a great job of juggling her time, I will say. She's also a member of the Board of Neighborhood Legal Services Association, and she represents plaintiffs in protection from abuse cases. So Julie, thank you very much for being here. Our other speaker is Judge Nicola Henry Taylor. She was a member of PMC's board. She was just recently elected to the Allegheny Court of Common Pleas, and we are so excited about this. Nicola is amazing. She just gives back to the community, in every way she can, and although I will say now, I'm sure you're a little more limited that since you're a judge, but she serves as the director of diversity at Duquesne University School of Law. She practiced in family law when she was a practitioner. She also is a member of the Dean's Diversity Task Force, the commissioner of Allegheny County Human Relations Commission. She's on the North Hill School District Anti-Racism Task Force. She's a member of the Pennsylvania Supreme Court's Interbranch Commission for Gender, Racial, and Ethnic Fairness. So I'm sure you're getting the gist of this. She's also a mom. And so she too is an amazing juggler, I will say, because it is really, and I know speaking from experience, I mean, these women are remarkable. They are caring, giving, and always interested in giving back. And without much further ado, I guess I didn't give a little brief. I did. Okay, so we did the survey. In case somebody joined us afterwards, Duncan, I don't know if you can up the survey again, because I know we had a few latecomers. And we're going to start with a very, very quick, so I'm going to speak quickly, information about the court, because I want you to understand the Pennsylvania court system and where family court cases fit in. Pennsylvania courts are a triangular structure. Our highest and usually court of last resort is the Pennsylvania Supreme Court, but our cases originate in the lower tier, I will say, of this triangle, as you see in the municipal court or magisterial district courts. The speakers will discuss about emergency PFAs beginning in magisterial district court. They're on certain, it's on the emergency basis, right? It's on the weekend, but majority of family court cases begin in the Court of Common Pleas. If you're not happy with their outcome in the Court of Common Pleas, I will say you have an automatic right of appeal to the Pennsylvania Superior Court, and another intermediate appellate court is the Pennsylvania Commonwealth Court, and then appeals from those appellate courts go up to the Supreme Court, but it is not an automatic right of appeal. It is that the Pennsylvania Supreme Court has discretion to take those cases. That is an extremely abbreviated discussion of the Pennsylvania court system. Your Honor, do you want to explain a little bit about the Allegheny Court Administration?
Yes. First of all, Deb, thank you so much for inviting both Attorney Colton and I to be a part of this, the civic engagement endeavor with you, PMC, and the libraries. It's an absolute pleasure to be a part of this. And if you don't mind, I just wanted to point out, because I did the court basics program with you before, and I'm not going to dwell on this, but just so that all the listeners know, is that the intermediate courts are broken up into the Superior Court and the Commonwealth Court. And it's my understanding that Pennsylvania is the only state that has a Commonwealth Court. And then with respect to the PFAs, you may get your emergency PFA, but then that will expire within a couple of days if you get it at the magistrate's office, and you need to appear at the courthouse to get what's called a temporary PFA, and then that you may get a final hearing date and you would be at the Court of Common Pleas level. So the chart does show that typically all of the family court cases do start at the Court of Common Pleas level, which is our trial court in Pennsylvania. So I will go to the to the court administration slide. And this is Women's History Month. So it's so exciting to look at this slide and see how Allegheny County is configured. Our president judge is Kim Berkeley Clark, which is the first African-American woman to be president judge of all of these divisions in Allegheny County. Our administrative judge for civil is Judge Christine Ward. And the type of matters that are heard there are torts, things like a blue car hitting red car, medical malpractice, those type of things, contract disputes. They may have arbitrations that start at the lower level, and they may handle landlord-tenant matters in that court as well. The other division next to that is criminal division, and Judge Jill Rangos is that administrative judge, and felony cases such as homicides and rapes and robberies are in there. Such other misdemeanors such as DUIs and adult probation is under that umbrella. And we have a lot of problem-solving courts in Allegheny County, such as mental health court, veterans court. In our family division, our administrative judge is Judge Kim Eaton. In our division, we handle a lot of divorce matters, child support matters, juvenile matters, children's court, protection from abuse matters, and we will drill down on those as we go along. Our orphans court is the fourth division, and our administrative judge is Judge Lawrence O'Toole. The type of matters that are handled over there are matters such as wills, estate, probate, trust, civil commitments because someone may have a mental health issue or incapacity that they need to be committed to an institution. Adoptions are one of the happiest things that happen in the courts, and those are typically handled in orphans court, and guardianships of alleged incapacitated people as well. So I'm going to pass this on to Attorney Colton for the next couple of slides.
Hi, welcome to everybody. And I want to tell you about the family court. It's located in the old jail building. When you see these two addresses here that say it's at 440 Ross Street and 550 Fifth Avenue, those are two separate entrances to the same building. Under the pandemic, it is best to use the 440 Ross Street entrance. There are some limits on entrance through the 550 Fifth Avenue. But the 550 Fifth Avenue address is where you're going to find our children's room. So if you show up at the courthouse and you need some childcare, that is set to open later in March with limited capacity and some COVID restrictions. But that's where we're located. And if you're into some history, you can read up on the history of one of the first divorces in Allegheny County, which took place with the warden's wife, and all the drama took place in the family court building. But moving on to family court basics. Our family court is divided into two branches, adult family court and juvenile family court. The easiest way to remember it is in juvenile court, it is the child who is on the caption. It is the child who is the person we are talking about the most. In adult family court, you have the adult who is part of the caption. So juvenile is dependency and delinquency, and adult family court is child support, child custody, divorce, and other related issues. We operate with a one judge, one family. So once your case is assigned a judge, that judge stays with your family for as long as you are with the court, and that judge is with the court. So if the judge changes divisions, that may change.
And I'm going to handle that slide. And to Attorney Colton's points, you may have one family that has a matter in adult, juvenile. Let's say one of the children ends up getting in trouble at school and has an aggravated assault on a teacher charge. They may have juvenile probation. So in this slide, you will see that in adult, you may have divorce. The parties may have child and spousal support to deal with. And if a child gets into trouble at school, they may have delinquency. In Pennsylvania, we also have something called Act 53. So if a child has a drug and alcohol behavioral health problem and they're refusing to go to treatment, the parents have an avenue to try to get them to go to treatment through a court order. We have a children's court in Allegheny County where we're dealing with domestic violence matters, child custody, child protective matters, which are dependency. That's when children, youth, and family services are involved. And we'll get into that a little bit more, where that can turn into a termination of parental rights. And we also have something called bypass cases where in this instance, it's the child trying to force something, and it's where a minor is bypassing the parental consent to have the option to have an abortion. So those are handled in family division as well. As we indicated, the next slide will show that the subjects that we're going to talk about, which I think Attorney Colton and I have already touched on, is divorce and spousal support and alimony, child support, child custody, and dependency court. I'm going to turn it over to Attorney Colton for the next several slides.
So I'm going to jump in here on divorce, and I see I'm not loud enough to trigger my picture, but sorry about that. If you can't hear me, just throw something up in the chat, but it looks like I'm loud enough. So divorce is our dissolution of a marriage. It's when we end the marriage legally. And there are two types of divorce. There's fault-based divorce and no-fault divorce. Most divorces in Allegheny County are no fault. You can get a fault-based divorce if necessary. If we move on to the, So when we look at false-based divorces, they are very complex for us to handle. And you actually have to do an additional hearing to determine the fault basis. That additional hearing does not affect your asset division. So fault rarely plays a role in the economic portions of the divorce, just in triggering your ability to get a divorce. And we talk about things like abandonment, extramarital affairs, violence to you, incarceration of the person, or even if the other spouse has a mental health issue that has had them involuntarily committed. In no-fault divorces, we have a couple different options. The first, you'll hear us refer to them as C and D options. That's literally just a letter in the citation we use, but it helps us remember it as lawyers. And the 3301C divorce is a consent divorce. You and your spouse both agree that you're going to get the divorce, and you filed an affidavit of consent and a waiver of notice within the appropriate time in order to allow the divorce to go forward. Part of that 3301C option there is if a spouse is convicted of a physical crime against the other spouse, the court will deem them to have consented to the divorce. So you can go through the consent process without the additional expense and length of a fault-based hearing. The other option under a no-fault divorce is a 3301D divorce. In a 3301D divorce, you have to wait a period of time. The current waiting period is 1 year. That's not 1 year from filing of the divorce complaint. It is 1 year from the date of separation. Separation can be a little tricky. It's usually when the two parties, when someone moves out of the marital residence, but it can be established while the people are still living together. After 1 year, forms are filed, and then a divorce decree can be requested after a few more forms go to the court.
Julie, I just want to ask you a question, because I know I've heard people say this, like, I don't understand how we could be separated and living in the same house, right? But, you know, in this day and age, housing costs are expensive. So there can be like I would almost say a physical separation in the house, right? And that would be considered a, separation.
Right. There was a judge in Butler County who I always say gave us the best definition. And you look at bed and bank. Have the marital relations in the bedroom or the marital finances in the bank changed? And with a tiebreaker of looking at the reputation. Does the community, your family, your friends still think you're married, or do they realize your marriage has moved to a separated period? There is no legal separation in the state of Pennsylvania, so you do not file for separation. Some important notes to keep in mind. You need to discuss that issue of separation with your attorney. You should also be talking to them about the economic claims, which include alimony and asset division. There are a number of timelines to keep in mind, so please be wary of deadlines. And it's always better to be early than late when it comes to deadlines, so you're not waiving any rights. If you obtain your divorce decree without resolving your economic claims, you cannot go back and fix that. You must do the economic claims first unless you have permission from the court to wait to address those. So make sure that if you're talking to someone and getting those economic claims properly preserved. And I had said earlier, no-fault divorces are the most common, and that is in part because they are the most affordable. A fault-based divorce costs a lot of money and there's no reward for it, except for what I always say is you got to prove they really did what they did.
I just want to emphasize that it is, it really is important to obtain counsel. This is something that while the Allegheny County courts have a great website, there's a lot of information available there. And I know the Allegheny County Bar Association has a family law section that also helps out. I personally think it behooves people to try to obtain counsel.
And when you're looking for counsel, you want someone who meets a couple of different criteria. You want to look at them being financially the right match for you, personality-wise the right match for you, and someone you trust. You're going to be spending a lot of time with this person, so you want to make sure that they're the right fit for your case. And it's okay to interview more than one lawyer.
And lawyers know that. I mean, in this day and age, lawyers know that they are, being interviewed to see if they are liked by the client. And that relationship is very important.
And may I add real quick, since I don't want to wait till we get to the support section, but the Allegheny County Bar Association has a lawyer referral service. So I know it's hard to try to figure out how to make the match. The pointers were excellent that Attorney Colton gave, but that's one place to start that has attorneys that you can, so you're not shooting in the dark necessarily.
Thank you. It is next.
No, that's not good. I'm transferring over to headphones to see if that made me trigger it. It didn't. Okay. All right. So we talked about.
You are showing up.
Okay, because I don't see myself. So that's why. Sorry about that. There are multiple types of support that we want to talk about here. There's two main categories: support for the child and support for the spouse. Child support lasts until the child is 18 and graduated from high school, whatever comes second. We do not have college support in Pennsylvania. Spousal support is support for your other spouse, and there are three different types. There's spousal support, and that's support before a divorce complaint is made, but when the parties are living separately. Alimony pendente lite is support that you can receive from the date a divorce complaint is filed until the date a divorce decree is issued. And alimony is support a spouse receives after the divorce is done. You only receive one, when it comes to the spousal side, you only receive one type of support for the spouse at any one time, but you could possibly receive all three depending on what's going on, or be required to pay all three. But they're all taken into consideration. And most of the support is guideline based, which we'll talk about in a second. So support of a spouse during the divorce. This is, like I said, that spousal support, the alimony pendente lite, which you're going to hear me call APL because it's just easier than tripping over the Latin, and alimony. When we talk about spousal support, we want to know that that is alimony based, and this is one of the only places that fault comes in. You don't get spousal support if you were deemed to be at fault in the marriage, but that's okay. because if you file a divorce complaint, you trigger the eligibility to get that alimony pendente lite, and you can still receive support then. So you want to talk to an attorney to make sure you're filing for the right type of support, and all of that can be, and the actual application is found online. Alimony itself, the third one, is not formula-based. That is a needs-based analysis that is much more complicated, but it is dealt with as a secondary remedy. That means we try and divide the assets. If that doesn't get us what we want to get equitable outcome for both parties, then we move on to an alimony with a review of budgets. If we move on to child support is guideline based. I always tell people, if you want an estimate of what your support may be based on guidelines only, if you Google Pennsylvania Child Support Estimator, you'll get a state government website that allows you to plug in some numbers and run some rough calculations. It is not 100% accurate. It's a starting place for your consideration. The court looks at your net income. That is not your take home. That is not your tax income. It is a number that the court has determined based on, they take your gross and take out a few expenses and then get your net income. They add those two together to determine what we're going to do, and it's guideline based. I find a formula, I pull up my book, I look where that number is when I added the two net monthlies together, and I slide over and it tells me what to do. They jump me to the next slide because I jumbled, but let me explain to you where we're going from that. If you look at this slide, you'll see that when the two parties have a combined $10,000 per month income, then I would pull up my guideline and it says 10,000 on the left side. I slide over to two children and it shows me $2,280 per month. If you earn 25% and your co-parent earns 75%, your co-parent would then owe you $2,500 per month. It's adjusted for that. Now, this assumes your co-parent has fewer than 40% of the overnights. If they have more than 40% of the overnights, we're going to adjust that calculation and reduce the amount of money they owe because they have the child with them more often. These guidelines were just updated, so they're accurate as to what the state believes it costs to raise a child. It is probably not what you think it costs to raise a child. But that's our guideline support. There are some additional expenses we take into consideration. When we look at the additional expenses, child care that you need for employment, daycare, preschool, that kind of child care, even some summer camps, are not included in the guideline and can be an additional amount of support eligible to you or a deduction to the payor to make sure that we are able to keep people in work, because we want the child support guidelines to promote both parties actively financially supporting the child. Activities can be can be added on top of the guideline amount, and unreimbursed medical expenses are not included. Unreimbursed medical expenses are your co-pays, deductibles, those out-of-pocket costs. The recipient of the support pays the first $250 per year, and if you go above that $250 cap, which we see a lot now in the world of deductibles, then we divide anything above $250 somewhere between 50-50 and that income split we talked about on the prior slide, where we get the 75-25.
Seems like it's a very methodical application.
They made it this methodical so that it's predictable and we have less fighting in the court to make it more cost effective as people go through the court system. We can still find ways that where we disagree and need to clarify items and maybe have to go to a hearing, but many times you'll see two attorneys sit down, run calculations, and come out pretty close because we know what the guideline is for what we have to do. If we look at the support procedure, the first thing you have to do is file a complaint. Like I said, that can be filed online through the PACES web portal. PACES stands for the Pennsylvania Child Support Enforcement System. And that is a statewide system to help us organize and oversee child support collections and enforcement. That can be filed by you or your attorney. I do suggest you talk to your attorney because when you file support, we want to make sure you're going to be the recipient or you know how much you could be on the hook for paying, because it can go either way as we go through the proceedings. If there's a question as to paternity, meaning who's the other parent, we need to make sure that we know legally who that parent is before we put a support order into place. The first step is a conference. In Allegheny County, that conference right now is by telephone or video conference, and it is intended to stay that way for a while. And they will collect information and attempt to have an agreement reached by the parties. If you do not reach an agreement as to what the support order should be, you're going to move to the next step. That is a hearing before a hearing officer. A hearing officer is a lawyer who is now a full-time employee of the court in Allegheny County, and their job is to hear support cases all day. Support cases are supposed to be scheduled for 20-minute hearings. Sometimes we go a little bit longer, even though we're not supposed to. And testimony is given on the record. Those support hearings are in person and set for a date certain. So when you're at that that conference on the phone, they should give you the day of your hearing officer hearing at the end of that conference if you don't reach an agreement. So you're ready, prepared, and know how to get into court. And we know everyone can do the date that it's being scheduled for, and we don't have any delays, needs to reschedule.
How does the hearing officer get appointed?
How do they get appointed?
Yeah, I mean, so people have confidence that they're independent, right? They're not one attorney doesn't choose a hearing officer versus, another attorney, right?
No, it's random assignment, actually, just like the judges. So when you look at the judges, they actually, when you file something with a court, somewhere in a back room, you get randomly assigned one of the judges that comes up after they do some screening to make sure that you aren't already connected or someone in your case connected to a judge. They do not assign them in our presence, lawyer presence or party presence. Then when it comes to hearing officers, it's the same thing. You get the person who is either the next slot available, or it may be based on your location. So if you are in the catchment for our Penn Hills support hearing office, you get the Penn Hills support hearing officer. If you're in our Mount Lebanon Castle Shannon hearing office, you're going to get the hearing officer for the Mount Lebanon hearing office. If you're downtown, you get whatever hearing officer had the next available slot for you to get slotted into. And you don't always know, if you're downtown, you may not know who your hearing officer is until you show up that day. Masters are also that's support hearing officers. All people who hear anything in the court, which are also our divorce hearing officers or our custody DROs and that we get to, are all assigned sort of behind the scenes. We don't get to hand pick them. And once you're assigned to one, you often stay with that same person. At the end of the hearing, after you put your evidence in, the hearing officer usually takes that matter under advisement. That means they're going to consider everything they've heard and they are going to make a recommendation. The recommendation is then mailed out. You have 20 days from the date of the recommendation to file exceptions if you don't like it. Exceptions are like an appeal from the hearing officer to the assigned judge. If no one files exceptions, the support recommendation becomes a final order. If you file exceptions, that recommendation becomes a temporary order that will be enforced pending the outcome of the exceptions. If something is changed in the exceptions, they correct that change all the way back, and so that if you were supposed to receive more, that goes all the way back to the original filing of the complaint or the current modification, not just to when they make the correction. And be careful with those exceptions. They're very time sensitive. So if you want to do that, make sure you're doing them timely and following the instructions.
Thank you. And I'm going to talk a little bit about custody. And before I go to that, I'll just say this. Attorney Colton very eloquently explained support. And obviously you would need more time with an attorney to go over that. But even though they're so methodical, it's still very emotional. If you're the litigant in court, we could, as the attorneys, run the calculations and explain to you this is why, but there is a very emotional component when you're in the case. And attorney Colton and I have actually had cases together trying to figure these things out. So just, keep that in mind. If you do get emotional, try to stay grounded and understand that it is a calculation.
I often say, oh, sorry to interrupt you, but I often say to people that it's advisable also to get an attorney, because hopefully that attorney will then help you keep your emotions, calm down, right? That the attorneys themselves shouldn't be emotional. They should be able to deal with each other, and that helps you as the litigant, helps you understand the situation a little better.
That's excellent advice. And if you get an attorney like Attorney Colton, they can walk you through the process and explain to you further all of those intricacies of the support guidelines, because we do not have enough time to go through all of the details, but thank you for touching on that. So as it relates to custody, the first type of custody we'll talk about is legal custody. And that's the right to participate in major life decisions in a child's life, such as education, religion, and medical decisions. And believe it or not, with COVID and a lot of changes that we've had in the world, people fight about these things quite a bit, whether it's what kindergarten the child's going to go to. So, that is something that comes up in court quite often. And usually legal custody is either shared, where both parties would participate. And if one disagrees, then you might file a motion with the court to get some movement. And if that's done, the court typically doesn't say your kid gets to go to XYZ school. They give one parent the choice to pick the school. So just so you know, if you're involved in that type of situation, very rarely this happens, but it does happen where one party is granted sole legal custody, where one party makes the decisions on major life decisions. And sometimes the court might say, at least notify the other party. Where that might happen is, for example, a child has serious mental health or intellectual disability, and the other party does not, they just are not helping, and the parent who is probably the primary custodian needs to have the ability to take care of this child and make these decisions. And so for that reason, after a trial or maybe a recommendation, that may happen after some evidence is taken. And when I say recommendation, there are sometimes psychological evaluators or guardian ad litems involved in cases that can help the court to understand why that's necessary. The next type of custody that most people are familiar with is physical custody. These are the types: primary custody, where one parent has the child more than 50% of the time, or partial custody, when one parent has the child for less than 50% of the time, or shared custody, when both parents have the child about an equal amount of time. That could look different ways. It could be week on, week off. It could be 5-2-2-5. There's different ways of putting that together, whatever meets that family's needs. Again, more rare, but sometimes necessary, is supervised custody, when one parent perhaps there's a safety concern. That parent has been accused of not caring for the child. The child has been hurt in that parent's custody. Maybe that parent has mental health or drug and alcohol, substance abuse problems, and would need to have someone supervise them when they are caring for the child. So those are the types of custody, and I'm going to have Attorney Colton. She's going to talk about some of the procedural aspects.
So when Judge Henry Taylor and I were trying to figure this out, we actually had to double check the procedure with the court, because it has changed a number of times during the pandemic for a number of reasons. So this is the current process, but be aware it may change some as we start to go back to a more normal court proceeding. So the first step in Allegheny County is always education. Right now, that is currently online. you'll see there's a website here that would be emailed to you if you have a custody case, along with a password to log in and download the educational material. Step 2 is mediation. Let me actually, before I do that, education you do once in your lifetime. Step 2 for mediation, you're going to do that at both establishment, meaning the first time you go through a custody case, and modifications, when you go back to change an order. Mediation right now is by telephone or video conference. It is with just the parents and a third party. Lawyers do not attend mediation, and mediation is non-binding unless you agree to turn the mediation agreement into an order of court. If after the mediation, normally, if it is the first time you have gone through the custody system and there is no underlying custody order, that means you do not have a temporary custody order or a PFA with an order of court, then you're going to be scheduled for a 1-hour interim relief hearing. The purpose of this is to make sure there is something in place, it's like a Band-Aid, so that the two parents know what's going to happen moving forward with custody while the case is pending, and no one is exercising what we call self-help. No one is taking the child and saying, I'm going to hold the child for now. We're kind of trying to keep the child out of the middle. If you already have an order, you will not see that interim relief process, and that interim relief hearing is about 1 hour in length. At this point, the path of custody cases divides. If the one parent is requesting partial physical custody, less than 50% of the overnights, then you'll be scheduled for a hearing before a partial custody hearing officer. We have 2 in Allegheny County, and again, they're randomly assigned. And that hearing will last about an hour and a half. And that process lasts just like the support process, so that you go ahead and have that hour and a half hearing. The hearing officer is going to give you a recommendation, and you can file exceptions within 20 days if you do not like the outcome and ask the judge to reconsider. If that nobody files exceptions, then that recommendation becomes a final custody order. And again, that recommendation will be enforced while the exceptions are pending. If the parties are asking for primary physical custody or shared physical custody, meaning 50% or more of the overnights, or asking for legal custody, that decision has to be made by a judge and cannot be made by a partial custody hearing officer. So on that path, your step 4 is a conference before a Generations Department domestic relations officer. It is akin to a case management conference. They're going to see what's going on, determine if anything needs to occur before you get in front of the judge, and try and settle your case. If no settlement is reached, you will then be scheduled for a judicial conciliation. That is a conference before your judge to again attempt settlement and to talk about what may be in the best interest of your child and get some input from the judge as to what may happen if you proceed in the case. If no settlement is reached at that point, the final step is the trial before a judge. Your trial before a judge can last 1 day, 2 days, or multiple days, but is usually at least 1 day in length. If we go to the next slide, the hearings before a judge, we're going to have full question and answer testimony. You're going to present evidence and witnesses. They do not want every single text message you have sent to your co-parent, but they do want to look at what is best interest of the child. So you may need some documentation to help prove that. Each judge in Allegheny County has their own set of standard operating procedures that you can find on the court website. And in those procedures, the judges lay out what they expect from you at a trial and what they expect from an attorney at trial.
I just want to say, I looked at Judge Nicola's procedures before this. They are very detailed and very clear and, easy to understand, which is, I'm sure much appreciated.
In addition to their standard operating procedures, you will get a pre-trial order. That is a document that tells you what you must do in order to be able to present your evidence and witnesses at trial. Make sure you read that order, you follow that order, or you may not have the freedom to put your case on the way you want to. Again, having a lawyer helps make sure all those boxes are ticked appropriately. If you need relief and it doesn't fit into one of those nice categories of those steps we talked to you about, Allegheny County has a robust motions practice. You can present a petition for special relief. It's the legal equivalent of triage. They used to liken it to MASH, and now I think we're all too old to remember the MASH TV show. So I'm at ER, maybe Grey's Anatomy. It's the Band-Aid we put on your gaping wound before we figure out what's really wrong, to give us temporary relief till we can get to a judge. Again, in Allegheny County, each judge has their own set of motions procedures. Those are found in their standard operating procedures. And there is one set of procedures that is being used right now because everything is virtual for motions practice. Beginning hopefully April 1st, there will be probably updated procedures issued, because some of the judges will be going back to live argument motions in the courthouse, and some will be staying with the virtual practice. So you really want to know what your judge's standard operating procedures are. And I think I kick it back to Nicola.
And we are working together for the adult judges to try to come up with some standard practices for the motions. We're probably not going to agree on everything, but our standard operating procedures will be updated. They're on the county website, as Deb said, and we'll continue to work to try to make them user-friendly and also to be trauma-informed, as we know that court can be traumatizing. So as Attorney Colton talked about, the fact that there are factors where the court are looking at the best interest of the child. And the slide that you should be looking at now does list, this is what the court has a roadmap to decide. How do you decide what's in the best interest? In every case, all of these 18 factors might not be present, but the court needs to analyze them, and oftentimes will have written findings indicating if it wasn't relevant. So I'll just say some of them. You can certainly read them, and if you were to have a trial in my courtroom, when we send out our trial pretrial order, as Attorney Colton talked about, we are adding to that the factors, so you know what it is that we're looking for and what we're required to look at. So the first question, which I think is the best question, is which party is more likely to permit continued contact between the child and the other party? It is in kids' best interest to have good relationships with both of their parents. They look at abuse of one party of a member of the household. So if dad or mom abused the other parent, that's relevant. Particularly if the child was involved or present, what each party does to parent the child. For instance, some parents might never have taken the child to a dentist appointment. They don't know the name of the specialist who deals with a speech therapy that the child needs. So those are some important things, such as extended family relationships with siblings. There might be half siblings in one home that if the child is away from, that's a factor that the court might look at. And this is a question that comes up often. People think there's this magic number that if a child is 12 or some magic age, that's when the court can talk to them. If, there are kids who are 13 that might not be able to express a well-reasoned, mature preference as to where they want to be. And so there are some tools the court could use. It could be a discussion with the child that's on the record called an in-camera hearing. There might be a guardian ad litem, or maybe even a court psychologist who's able to ascertain the child's well-reasoned preference or not so well-reasoned preference. I mean, if a child wants to go to mom or dad's house because they stay up late and eat ice cream, well, then the court's going to look at that. And some other factors, is the child doing well in school, and those things. So I'm not going to go through every single factor, but just so you know, there is a roadmap for the court, and they're very important. And so we would recommend that you have an attorney, but if you ever have to do this on your own, the court would be most interested in these factors for a custody case. I'm going to move to dependency now, and that's in the juvenile law branch that we explained when we went over the overview of the court. And that's when CYS may get involved. Let's say they get a call that a child, and you've seen this on the news, a child is walking around in diapers in the cold and there's no parent to be heard of. So they may have an emergency call, they come out and they have to take care of that. And Children and Youth Families in Allegheny County is under the Department of Human Services. That department has many other forensics or human services, justice-related services that they do. But in this instance, they are looking at whether or not they may need to, with the help of their solicitor, file a dependency petition because the minimum standard of care of a child, their physical, intellectual, and moral well-being is not being taken care of. That could be because of lack of parental care. Maybe the parent is drug addicted. Maybe the parent has co-occurring disorders with mental health. If a child, and typically, obviously, these are school-age children older, if they're habitually truant, usually there's some other issues in the home, but that may trigger CYS being involved. If there's habitual disobedience, sometimes the parent is doing all they can, but you may have an oppositional defiant teenager. And if this child's continuing to run away, if the child's using drugs, if the child is engaging in risky behavior, then even if you have well-intended parents, that may be under A6 of the dependency statute sufficient for CYF to be involved. Now, just keep in mind, not all cases that have these issues become court involved. Oftentimes, there are many cases that CYF deals with, that they work with the family, and it may not become court involved. But we're talking about the most serious cases typically where ultimately a petition for dependency is filed. If the child,
oh, I'm sorry to interrupt you, but some CYF is contacted sometimes by teachers, doctors, friends, right? I mean, they don't necessarily know on their own, but there are friends of the child who sort of alert CYF to this.
As lawyers, after the Sandusky issue, we are mandated reporters. So as a guardian ad litem, or even psychologists, if they are in the middle of dealing with a child and they see that there are safety concerns, they have to alert CYF and maybe do a child line, and there's a number online. And typically those are protected. If you call in and you have a concern, they don't report out to everyone who the caller is. Now, I do have to apologize. I have to be in court, so I'm moving a little quicker than I was.
Fine. Sorry about that. Okay.
Oh no, it's okay. I have to be in court at about 1:30. We're getting really close to that time. Close. So the next thing I want to go over is the process of how it might become a termination of parental rights. So typically, we talked about that baby walking around with a diaper on in the cold. That typically would, once the CYS gets involved in a situation like that, within 72 hours, they have to have what's called a shelter care hearing. In some other jurisdictions, you may have heard of it as a detention hearing, but ultimately, as the caseworker may call into the court, they may get an emergency custody order, but by law, they have to have a hearing where that's put on the record, and the court will determine if the child is removed and placed in a kinship care or some other setting, whether or not the child would stay in that setting. The petition hearing in Allegheny County is also called an adjudication hearing. That typically happens between 10 to 30 days after the shelter care hearing. And if the case is not totally dismissed or maybe they work something out at shelter care, there's an adjudicatory hearing with evidence. They might be a doctor from Children's Hospital. They have to prove their case by a clear and convincing standard. And so it's a very important hearing, and hearsay is typically not allowed in that hearing. If the adjudication happened and the court feels that it's the solicitor's office that represents CYF, if they've proven their case, then in Allegheny County, they do the disposition at the same time. Some counties will separate that, but that's where the court determines the child is adjudicated dependent, but what should we do? Could the child remain with the parents or be placed back with the parents? Is there kin, family members, even if it's not blood, people who have a relationship with the child, just working through all of those issues for the family. And there are review hearings typically every 3 months, and the court would like to see the children on a regular basis. And so sometimes children are made available for these hearings. If the case cannot be resolved and the child's out of the parent's care for 15 of the past 22 months, the agency under the Safe Families Adoption Act should be filing a termination. There are other dispositions. Sometimes it could be maybe the child is with an aunt and the aunt doesn't want to be an adoptive family, but they may want to be a permanent legal custodian. That's an option. And so, but if we don't have those options, we're going to move to termination. And although that's technically in orphans court, the family court judge basically just puts on a different hat, and they will take care of the termination of parental rights case. And that is a very serious hearing that it's been called by the appellate courts the death penalty of family law. I have been on the side of representing parents in those matters. It is a very difficult proceeding. The parents could opt to sign a consent to adopt. They may enter into an Act 101 agreement. Those are totally voluntary. The court cannot force that, but that's another option if we get to the point of termination. And the parent may decide, or both parents may decide, I know I can't parent. I didn't get my act together within the allotted time, and I would have some relationship with my child. So I am so sorry, but I am going to.
Okay, thank you.
And then if you and Attorney Colton can handle the rest of it, I'd appreciate it.
To me, the most important part is the issues of representation, right? Here,
Yes. Oh,
you know, so, go ahead.
no, you hit the nail on the head. I totally forgot that this is one of the rare places in family law where you have an absolute right to an attorney. And that was because of litigation where parents were losing their rights and they were not represented. So if in Allegheny County, you have a dependency case, we have a parents advocate through the Bar Foundation. If you can't be represented by them because there's a conflict, we also have a list of conflicts counsel. And we have teams where each judge may have the same parent advocate, same conflicts counsel. The child and children get representation through Kids Voice, and they are present. So there are oftentimes 4 or 5 attorneys on these cases, and so much attention is given to the cases. So with that, I'll end, and
Thank you, Your Honor.
Allowing me to participate.
We very much appreciate your participation, and we completely understand that you want to be on time. So thank you. Really, do you want to? I mean,
just to
Nicola,
follow,
right?
yeah, I can jump
but
in.
Go ahead.
Just to follow up on the representation piece.
Right.
Outside of this area where we see termination of parental rights, there is one other area where you will receive counsel, and that is on a support contempt matter. Because the county sends a solicitor to represent the county's interest in collecting support, meaning preventing the child from becoming a dependent of the state and collecting TANF funds, the court then also provides an attorney for the payor who is delinquent, because this government is not allowed to represent themselves and put you at uneven footing if you're a payor who's not paying. If you ask for a protection from abuse order, Neighborhood Legal Services does provide everybody the opportunity for counsel, and that is not a guarantee of counsel. That means there is a pro bono attorney who will reach out to you and assess your case and may choose to take your case on if you are the plaintiff in a protection from abuse matter, meaning you asked for a protection from abuse petition and order. Defendants in protection from abuse matters do not have a right to counsel. That is not a criminal proceeding. So there is no right to counsel in most of the family court. And if you're interested in representing yourself, you can, but I usually would recommend always recommend that you have an attorney you're working with, because it is not, family court's not simple. It's tricky, and it isn't a clear written path that can be followed. There are a number of steps you have to take and hoops you have to jump at times, and having an attorney to guide you through that and make sure that your needs are being met and appropriately addressed with the attorney can be very helpful. And sometimes that's as simple as ferreting out the facts that are important to the parent or the spouse, as opposed to the facts that are relevant to the court action. So things that feel very emotionally important may not be legally important, and trying to make that distinction is very, very difficult.
Thank you so very much. This was truly special and very informative. And thank you all for attending. Thank you to the Allegheny Law Library and the Carnegie Library, and stay tuned. Please join us at next month's presentation, and have a great day. Bye.
Thank you, everyone.